My presentation is going to be a 15-minute presentation, and I'll just have a brief introduction of the law in Zimbabwe as regards criminalization of HIV, and then discuss the cases that we have handled. I've filtered my discussion to two cases. It would have been one, but I had brought in a case which was the first criminalization case in Zimbabwe in 2004, and that is the state versus Kaiboni Mlambo. Then there is the state versus Saletaengwa. Sam Kelisiwe Mulilo, this is one of the cases that I'm going to discuss. Then the state versus Nevison Mpofu, and state versus Malando Ncube. In the compendium, you will see that there are a number of cases, I think about two, which are not listed there, which are very good judgments, but we're not involved in those cases. But I would encourage you to really go and look them up and read them. For example, the case of Rebecca Ndaiziwe Semba is in the compendium, and it was Justice Hungwe, who was also a beneficiary of the training that UNDP did with ARASA and ICJ sometime in 2009. You can actually see from that judgment the benefit of capacity building our judges, and I think the previous speaker has highlighted how well knowledgeable judges would be of benefit to this fight against criminalization. So previously it was provided for under Section 15 of the Sexual Offences Act, but now it is under Section 79 of the Code. This is a law which we have argued many times before that it is vague and it is overbroad, and it is a dragnet in that it sought to punish all that it sniffs, and also it brings along in its train a whole lot of categories of persons that are at risk of prosecution. It provides that any person who, knowing that he or she is infected with HIV, or realizing that there is a real risk or a possibility that he or she is infected with HIV, intentionally does anything or permits the doing of anything which he or she knows will infect, or does anything which he or she realizes involves a real risk or a possibility of infecting another person with HIV, shall be guilty of deliberate transmission of HIV, whether or not he or she is married to that other person, and shall be liable to imprisonment for a period not exceeding 20 years. Quite a mouthful, as you can agree with me, especially around the issue of realizing real risk or a possibility, etc., but we will engage with that aspect later on. And we've highlighted that the problem with this piece of legislation is that it is poorly drafted, overbroad, counterproductive, and is at cross purposes with the public health goals of Zimbabwe. It is unjust, unconstitutional, and facilitates gross violation of human rights. And persons can be convicted without proof of actual infection of complainant. And the aspect I have highlighted about realizing the real risk or a possibility of infecting another person. The provision further states that for defense, it shall be the defense to a charge under subsection 1 for the accused to prove that the other person concerned knew that the accused was infected with HIV. As you can agree, proving in a court of law that the person who was infected actually knew that the other person, and actually proving that you have told them that you are HIV positive. Someone can just say you didn't tell them. And also consented to the act in question, appreciating the nature of HIV. So actually the aspect of appreciating the nature of HIV, what does it mean, and how can we say someone appreciates the nature of HIV? To what extent is that appreciation? And the possibility of becoming infected with it. So it allows also a voluntary assumption of risk. So in terms of the cases that we have handled as Zimbabwe Lawyers for Human Rights, this is just a bullet point of the issues that have emerged over the years especially around proof of HIV status, proof of infection, and the elements of in defense I've highlighted, intention, and also we have also encountered issues of inadmissible evidence being admitted, disproportionate sentencing, lack of understanding by accused persons of what they are being charged with, forced HIV testing, like in the State versus Sally Tayengwa, she was taken to Harare Hospital, and they said, "We are not going to leave this hospital until you are tested of HIV." So that was compulsory testing. The proper recording of guilty plea, the State versus Nevison and POF. It's not in the compendium, but again, probably it's going to be circulated by SALC, where courts not ascertaining if the accused has applied himself to the nature of the charge. If you saw the video yesterday of Sam Kelisiwe, she didn't know what was happening. She was there in the court, but she didn't have a clue she would probably be hearing voices, but not knowing what's happening in court and what is the magistrate saying, what is the prosecutor saying. It was a period of bewilderment for her when she was confused and etc. And the use of condoms, the role of the media, and the gender dimensions of criminalization. We had a case of S versus Malando Ncube, where the High Court judge ruled that if a person is charged under this provision, the court cannot order an HIV test. So when Malando Ncube is a former member of parliament in Zimbabwe, unfortunately he is late. So he was accused by a journalist for having infected her with HIV. So they went to court, and then we approached the High Court with regards to the order of the court that he undergoes an HIV test. Then the court ruled in his favor and saying that the magistrate had erred and cannot make such an order compelling him to go for an HIV test. But in the other cases, it was a matter of the accused persons admitting that they were HIV positive. But as recently as 2016, an amendment to the Criminal Procedure and Evidence Act have provided the courts with the powers to, in ascertaining the health of an accused person, to make an order for the taking of a sample of saliva, blood, or a tissue. Evidence of the results will be admissible, and it shall not be admissible for the simple fact that it was taken against the will of the accused person. So this was after the Malando Ncube judgment. We said the court cannot make such an order. The first case I want to talk about is State versus Kaibone Mlambo. This is the first case of criminalization in Zimbabwe, which happened in 2004. I think it was before September 2004, before N'Djamena, as it was provided for under Section 15 of the repealed Sexual Offences Act. There were two charges preferred against Kaibone Mlambo. The first one was that he had slept with a girl below the age of 16 and that he deliberately or willfully transmitted HIV virus. I'll not dwell much on the first charge, but suffice to say that from the court record and also the evidence led, the complainant, there was no evidence that the complainant was tested HIV positive. But the facts goes like this person, Kaibone Mlambo, a DJ, was a very popular figure in Mutare, which is a small town of I think about 200,000 people in terms of population. So I highlight the population figure so that you can know, you can bring into perspective the role of the media, especially where people follow the media in small cities and everyone knows the other person. So he admitted consensual sex with the complainant but denied that the sexual intercourse was unprotected. He also denied that he was HIV positive and that if he was, he did not have knowledge of it, actual or otherwise, and accordingly did not willfully transmit or intend to transmit HIV. He also said he used a condom, so even if he was HIV positive, he took steps to prevent HIV transmission. So there are points of difficulty in this case. Proof of complainant's HIV status was not produced in court. But this might also be argued that it is not important, probably because also the issue of the Act, the provision also criminalizes HIV exposure. Proof that the complainant did not have HIV before she met Kaibone Mlambo. Or if she was, the aspect of who infected who. She might have been infected before the sexual encounter with Kaibone Mlambo. And Kaibone Mlambo might also have been positive also from another source. So these were the issues that the court were shy to interrogate. So there are other things now in terms of the doctor-patient confidentiality, because in this case, the doctor of the accused person was the father of the complainant. So he came and gave testimony in court that he had tested the accused person, and the accused person has tested HIV positive. And another medical doctor also gave evidence to the same effect, right? But there was no proof that when they tested Kaibone Mlambo, there was pre- and post-counseling sessions conducted, right? So it became probably apparent that when they did the test, it was not a voluntary testing, because there was also no evidence on record that there was pre- and post-counseling. And that also showed that the accused person, if there was no pre- and post-counseling, he could not have probably not known that he was HIV positive. So also in terms of statutory instrument 41 of 04, it is not lawful for a doctor to divulge information pertaining to his patient. Even though Zimbabwe Lawyers for Human Rights objected to the doctor's evidence, the magistrate surprisingly ruled that it was admissible. As also, this was against public policy in terms of Section 295 of the Criminal Procedure and Evidence Act and the General Public Health Policy encouraging VCT. So the evidence was taken by the court, and the objection was not successful. Accused admitted sexual intercourse but said that he had reasonable cause to believe that the complainant was of above age of 16. He said on the occasions he had sex with complainant, he used a condom. This was not disputed because there was no evidence to the contrary. The complainant had not been tested for HIV. He said he did not have actual knowledge that he was HIV positive, and that could not have known that he was likely to lead complainant to become infected with HIV. Further, he denied that he was HIV positive at all material times. He said if he transmitted HIV to the complainant, which he denied he did not do so willfully or with knowledge. So the aspects of awareness or knowledge of serostatus and criminalization emerged from this issue. But if you look at also at the cases that followed, and recently in the compendium, you see that the High Court of Zimbabwe have made some compelling arguments that will probably shift this position for the better in terms of what we are trying to achieve in terms of advocacy against criminalization of HIV. So in terms of the media, there's a publication called Manika Post. It's the widely circulated newspaper in Mutare, which was very vocal about this case and cultivated a lot of stigma in the community. They even convicted the accused before the trial. And it was brought up to the attention of the magistrate again in terms of the coverage that was happening and the stigma, etc., and the contemptuous nature of the reporting that was happening. The magistrate then wrote that if Kaibone Mlambo is a problem with the media, he can sue the media on another platform. So you could see that the court was also insensitive to the aspect of the media and also to the rights of the accused person. So this is another dimension which has also been cutting through all these other cases in terms of the role of the media in criminalization. So after two doctors and complainant gave evidence, the accused was, however, found guilty of doing anything which had likely to lead to another to be infected with HIV. He was sentenced for 15 years and 5 years was suspended. And unfortunately, he died whilst we were in the process of appealing against conviction and sentence. Then there's the case of State versus Kelisiwe Mulilo, which is that video you saw yesterday. This is the case we also took to the Constitutional Court, and of interest to this case is the questions around dolus eventualis and dolus directus, actual intent and constructive intent in terms of in criminalization of HIV. There is a case in the compendium which was also highlighted by SALC, Rebecca Ndaiziwe Semba versus the state, which was judgment was given by Judge Wongwe, Justice Wongwe. Is also very important in trying to unpack and unlock the logjam in terms of actual intent and constructive intent around criminalization and the provision in Zimbabwe. I think if you would read that, it would provide also greater insight, and I think it would be a very useful, it will provide useful capital to us as we discuss the way forward of criminalization in Zimbabwe with my colleagues present. So the accused, not fully aware of the nature of the charge, was facing, and this was paraphrased to here. Women and criminalization, we highlighted the issue of antenatal care status, gender violence, of the aspect of who infected who. If you're a woman, you are pregnant, you go to the hospital, you are tested, you come back. It's like the moment you come back from the day of testing is probably, it's like you're bringing the virus into the womb. Probably the men would have brought the virus prior to that, but because you get tested, it's like you're the first you're the one who have brought the virus into the womb. Then the aspect of gender violence, Kelisiwe Mulilo was, I think, subjected to a lot of gender violence before she was reported by the husband that she was the one who had infected. Yeah, it brings the dilemma which we call the first to the police station dilemma. If in a relationship people are living well and there's disclosure that has happened and there's this law, and when things turn sour, someone would just rush to the police station and report, because the police arrest and investigate later, then the other person who is left home becomes the accused person, and things will flow with that on that premise. So the Constitutional Court dismissed the application. What we had brought before the court was that the provision, Section 79, was unconstitutional on the basis that it violated the right of protection of the law under Section 18 of the previous Constitution, and also it discriminated against people living with HIV under Section 23 of the previous Constitution. So on those two grounds, our application was dismissed. The court said that the law is sufficiently precise to regulate individual conduct. It also found that there was no unfair discrimination, since there is no listed constitutional ground which protects persons living with HIV from discrimination. Of course, the Constitution did enumerate some of the grounds that people cannot be discriminated, but HIV was not part of that, and the court said that HIV is not part of that, and also that the provision was drafted to such an extent that any subject would be able to conduct themselves adequately in terms of the law and not fall foul of the law as it were. According to the court, Section 79 embraces both actual intent and constructive intent. That is to say, it protects society against those who intend to infect others with prior knowledge of their status and those who act recklessly with the knowledge that they could be positive. So there are two, if not three, issues from this case that we do feel, and also other experts like Professor Feustal from Zimbabwe, does feel that the court might have gone further to interrogate. For example, court should have inquired into whether it is appropriate for the offense that constructive intention should be sufficient basis for conviction. And also during the court, Justice Patel had asked the advocate who was appearing on behalf of Zimbabwe Lawyers for Human Rights whether there are any offenses that of which constructive intent was not a constitutive part, and if there are if there are such offenses, then would Section 79 or criminalisation of HIV be considered to be part of those crimes? So two issues really come up in terms of Section 15, which defines realizing the real risk or a possibility of infection from the judgment, the issue of awareness and recklessness. The court explained that it has two elements, that is awareness and recklessness. So an accused person has to be aware that the conduct might give rise to the consequences, right? The consequences in this instance, because the act is broad, might be exposure or the actual infection of a person with HIV. And recklessness, aware that despite the awareness, accused proceeded with the act, with the conduct. Where awareness, if proved by prosecutionness, recklessness is inferred from the fact that the consequences or result actually ensued arising from the conduct of the accused and the relevant circumstances existed when accused and engaged in the conduct. So the consequences or a result might be exposure, not necessarily infection. What we would have done, according to the questions that were raised by the court, as to whether there are other crimes which constructive intent is a constitutive part, if there are such crimes, would this section or would this section be considered, can it be considered to be part, would the court consider that this would be a good provision to be part of those offenses? So this would have required a supplementary heads of argument to show that such offenses exist from our end, and why Section 79 should be regarded as a case for such offense. So that is also still open to debate, and I think as we engage on the way forward, we're going to engage with that. So the way forward, in my opinion, I think would probably have to approach the High Court with an action procedure to allow for the leading of expert evidence, and also identify a client with a powerful story, such as to expose the falsity of the court's view that the provision cannot be used to charge innocent and indeed vulnerable groups. Right. I've done this way forward with regards to the Constitutional Court, but again there will be other debate around the use of the jurisprudence generated from the High Court, which is very progressive in my view, and would provide a very powerful arguments when people are brought to court and charged under this provision. Thank you.
Thank you so much, Tinashe. I mean, it just goes to show that these sort of cases are not simple cases to litigate on. And a lot of it depends on the court you're in, the jurisprudence, and really the level of education you need to do with your judges, which is where expert evidence and those things become critical in order to dispel some of the issues. And I think what also comes up is issues around the assumptions we had, and we discussed it yesterday, around morality and how it relates to issues of HIV and TB.